part of the rules that we're going to discuss is the regulation of the legal profession. The regulation of the legal profession and this portion of the rules makes up 6 to 12% of your total MPRE examination. It's really important to keep those percentages in mind as you prepare for this exam. You'll notice that not every subsection of the rules are tested equally. So while we're not going to cover every single rule of every single section together, I am going to point out those rules that people tend to struggle with and that we get a lot of questions on. The first rule that we're going to cover together from this first subsection, the regulation of the legal profession, is about the power of the courts and the regulation over us as attorneys as it relates to our legal services and our non-law related services. So to start, let's talk about the language of the rule first. So the rule says that a lawyer is not only subject to discipline as it relates to their law-related services in these model rules of professional conduct, but also with respect to the provision of non-legal services, if those services are provided by the lawyer in circumstances that are not distinct from the lawyer's provision of legal services to their clients, or in other circumstances by an entity that's controlled by the lawyer, individually or with other people. If the lawyer fails to take reasonable measures to assure that a person obtaining these law-related services knows that the services are not legal services and that the protections of the lawyer-client relationship do not exist. So that is the language of the rule. Let's give you a quick example about what this looks like. Let's say that you are a lawyer and you are also a CPA or an accountant. What this rule is saying is that you will not only be subject to regulation by these rules as it relates to your law practice, but you will also be subject to regulation by these rules as it relates to your accounting work. The way you can avoid this is if you make sure that you keep your law-related services separate and distinct from your accounting services. If you fail to take measures to keep your services separate and distinct, then you will be subject to regulation by these rules for all services, those legal and non-legal services that you render to your clients. It's helpful, and I feel like this rule is a really good example of what I'm about to say, but it's good to keep in mind that these rules are placing the burden on us as the professional to always make sure that when we are dealing with clients and when we're dealing with the public, that the person you're dealing with, the client, understands who you are to them and understands whether or not they are in a lawyer-client relationship with you. The burden is on us to clarify our relationship with them, and if there's any doubt, we should make sure that we take those extra steps to clarify, what we are doing for the client, what we're not doing for the client, and what type of relationship we have with them, if any at all. If we fail to do that, we can find ourselves subject to possible discipline by these rules. The next rule in this subsection that I want to discuss is regulation after we become admitted to the bar, or lawyer discipline. And I think it's helpful to first be reminded kind of by an overview of how this whole process or system will work. So usually disciplinary proceedings begin when a complaint is made about an attorney to the state bar. And at this moment in time, whatever body that receives this complaint, maybe there's some sort of grievance commission created by your state bar, they're going to go through these complaints and try to be able to sort out those claims that have merit and try to get rid of those frivolous claims. Because as we know, sometimes frivolous claims are of course made against lawyers who really haven't done anything wrong. So first the complaint is made, and then the second step is that these complaints are screened. We try to determine which have merit and which are frivolous. If the state bar decides that a complaint has merit, the attorney is then contacted and of course put on notice that a complaint has been made against them and that there's going to be a proceeding or hearing on this. And at this moment in time, most lawyers obtain their own lawyer to be represented in this type of proceeding. During that proceeding, that is when, of course, the complaint is discussed and investigated, and that is when the state bar will determine whether or not the lawyer is going to be subject to discipline for whatever happened. So that's the general overview of how this might work. The next part of the rule discusses where we as lawyers are subject to discipline. So the plain language of the rule says, lawyers admitted to practice in a jurisdiction is subject to the disciplinary authority of that jurisdiction where he or she is admitted to practice. This is regardless of where the lawyer's conduct occurs. So let's stop there for a second. What this rule is saying is if you are licensed to practice law, let's say in state A and state B, and you steal your client's money in state A, this rule is saying you are not only subject to discipline in state A, where the conduct occurred, but you are also subject to discipline in state B. Why? Because though the conduct did not occur there, you are admitted to practice there, and therefore state B can take action against you. The next part of the rule says a lawyer not admitted to practice in a jurisdiction will also be subject to the disciplinary authority of a jurisdiction if the lawyer provides or offers to provide any legal services in that place. So again, stopping there to give you a quick example, this portion of the rule is saying that if you are not licensed to practice in a place, but let's say you pretend that you are. Let's say you open up a shop and you start advertising legal services, though you're not licensed there. That place can take action against you for offering legal services, though you're not licensed to practice law there. So the big takeaway from this rule is that lawyers can be subject to discipline in multiple places for the same course of action. Meaning you could do one wrong thing or steal your client's money, but be subject to discipline multiple times in different places for that one course of conduct. The next rule that I would like to discuss is really a choice of law issue. So here the rule states, in any exercise of disciplinary authority of this jurisdiction, the model rules of professional conduct to be applied shall be as follows. First, for conduct in connection with a matter pending before a court, the rules of the jurisdiction in which the court sits will apply. So let's stop there. Let's say you are representing a client in front of State B court and you commingle funds with that client. This rule is saying that since what you did, the commingling of funds, is in connection to the representation of a client in front of State B courts, State B's rules will apply to your conduct. The next part of the rule says, for any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred. Or, if the predominant effect is in a different jurisdiction, the rules of that jurisdiction shall be applied to the conduct. And then there is an exception to this rule that I would like to point out. So the exception to this rule says, a lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which they reasonably believed the predominant effect of their conduct would occur. So to give you an example of this, let's say Attorney Andy is admitted to practice in jurisdictions A and B. Jurisdiction A permits lawyers to participate in for-profit referral services. Jurisdiction B, however, does not permit this. Attorney Andy would not be disciplined by Jurisdiction B if he chose to participate in those for-profit referral services that only referred him cases that took place in Jurisdiction A. Why? Because he's taking steps to ensure that the predominant effect of his conduct is occurring in a place where his conduct is in conformance with the rules, and therefore he shall not be subject to discipline by Jurisdiction B. The next part of this rule discusses the effects of sanctions in one jurisdiction and on another. And the rule specifically talks about this in the context of states as well as our federal court system. So first, the rule discusses states. It says sister states generally accept the disciplinary action by one state as conclusive proof of misconduct, but they may apply their own sanctions for the misconduct. So let's stop there. This is saying that if I'm licensed to practice law in state A and state B, and I steal my client's money in state A, let's say state A receives a complaint about me and opens up an investigation regarding my action, and they discover that I did, in fact, steal my client's money. This means that in state B, they are not going to reinvestigate that issue. Instead, they're going to take state A's investigation of my conduct as fact, as conclusive proof as to what happened. And the only thing left for State B to do is to determine what type of discipline they want to subject me to for stealing my client's money in State A. The next part of the rule talks about this effect in federal courts. So it says, the fact that a state disciplined a lawyer is evidence of misconduct in a federal proceeding, but the federal court must make an independent evaluation. So here, they are not going to take anything as conclusive proof, and they are in fact going to reinvestigate themselves whether or not I stole my client's money. So again, they can read and understand what state A investigated and what they did, but that is not going to be conclusive in a federal proceeding. They will take their own investigative action. The next rule we're about to discuss is a big rule, and it's a lengthy one, so I'm going to kind of break it into different chunks to talk about it. And this rule outlines what is misconduct. And obviously, we are all preparing for the MPRE, so this is a very important rule. The rule here says that it is professional misconduct for a lawyer to first violate or attempt to violate these rules, or knowingly assist or induce another to do so, or to do so through the acts of another. So just stopping there, the first part of this rule says it is misconduct if you violate the rules. It's that simple. Or if you try to violate the rules, or if you ask someone to violate the rules for you, or if you violate the rules by virtue of someone else's conduct, let's say like your secretary or paralegal or law clerk, that would all amount to professional misconduct here. The second part of the rule says that it's professional misconduct to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So again, to stop there, the rule tells us that any offenses involving things like violence, dishonesty, breaches of trust, or some sort of interference with the administration of justice would fall under this rule. It goes on to tell us that a pattern of repeated offenses, even those with a minor significance, when they're considered individually and separately, can indicate an indifference to the legal profession. So to give you a few examples here, let's say that lawyer Larry cheats on his income taxes. Even though this type of conduct, cheating on their income taxes, is not connected to his law practice, he would be subject to discipline because that's a criminal act, and that of course reflects adversely on his honesty and trustworthiness because he's lying. Another example for you, let's say Attorney Allen was caught driving slightly over the legal limit for intoxication and convicted of driving under the influence. A single offense may not be sufficient here to get him in trouble. However, if the same incident happened more than once, now this may result in professional discipline because, again, that's a pattern of repeated offenses that start to look like maybe this person has a problem and, of course, an indifference to the law and following the law and, of course, the legal profession. The next part of the rule says that it is professional misconduct to engage in conduct that involves dishonesty, fraud, deceit, or misrepresentation. So, for instance, cheating on the bar exam would fall into this category of misconduct. The next part of this rule says engaging in conduct that's prejudicial to the administration of justice is considered professional misconduct here. So let's say a lawyer who's in the course of representing a client, if they knowingly manifest by words or their conduct some sort of bias or prejudice based upon things like race, sex, religion, someone's national origin, disability, age, sexual orientation, or their socioeconomic status, that would violate this rule here. The next part of this rule says that it is professional misconduct to state or to imply an ability to influence improperly a government agency or an official, or to achieve results by means that violate these rules or another law. So an example of this would be if lawyer Larry said something like, "Judge Johnson owes me a favor, if you know what I mean. So I think if you hire me, your case will turn out well." That statement right there illustrates this lawyer's ability to improperly influence this judge in the outcome of this matter, which would then therefore be professional misconduct. And then the last prong of this rule says that it is professional misconduct to knowingly assist a judge or some sort of other judicial official in conduct that's in violation of their applicable rules of judicial conduct or other law. So again, if you're dealing with a judge or maybe a referee, you're not allowed to assist them in violating their own rules of professional conduct either. The next rule that I would like to discuss is a rule that a lot of people think they know well, but they don't really take the time to read the rule and understand what the words are communicating to them. This rule is all about our mandatory reporting requirements. I know most of us are familiar with the fact that lawyers have to report other lawyers for their misconduct. But what a lot of people do not understand is kind of the more specific inner workings of this rule. So first, turning to the language of the rule, it says, a lawyer who knows that another lawyer has committed a violation of these rules that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness in other respects, shall inform the proper authority. If the lawyer does not report that other lawyer, then the non-reporting lawyer is subject to discipline. The same rule applies to reporting judges. So what does this rule mean? I treat it like a two-part test. First things first, they say if you as a lawyer know that another lawyer has violated a rule, let's stop there. There is a knowledge requirement here. The rule uses the word knows. So in a fact pattern on the MPRE, you are looking to see if the lawyer knows that another lawyer has committed a rule violation. Once you've decided whether or not the fact pattern tells you that the lawyer knows about this rule violation, the next part of your assessment is whether or not that rule violation raises a substantial question to that lawyer's honesty, trustworthiness, or fitness in other regards. So what this really means when we take a step back is that not every single rule violation must be reported. Instead, this rule is saying that we must report rule violations that raise a substantial question to the lawyer's honesty, trustworthiness, or fitness. So to give you a few examples, I think double billing and double billing on purpose, that's fraud. If you come to find out that your coworker is double billing, that is definitely the type of thing that raises a substantial question to that person's honesty, trustworthiness, or fitness. And that is the type of thing that you should report, because if you don't, you're going to find yourself in trouble too, because we have an obligation to report. So again, a two-step test, always check for knowledge, and then once you determine there's knowledge, check to see if it's the type of thing that raises a substantial question as to the other lawyer's honesty, trustworthiness, or fitness. The next rule in this subsection that I would like to discuss is about multi-jurisdictional practice. So this rule has a few different parts to it. The first part of the rule I want to discuss is where it discusses when a lawyer cannot practice in a place or in a jurisdiction. So the rule says that a lawyer who's not admitted to practice in a jurisdiction shall not establish an office or otherwise continuous and systematic presence in this jurisdiction for the practice of law. So to stop there real quick, that's just saying that if you are not licensed to practice in a place, you shouldn't set up an office and start advertising, because doing that, assuming that the rules do not give you the privilege to do so, would be grounds for discipline. The next part of the rule says that a lawyer not admitted to practice in a jurisdiction shall not hold out to the public or otherwise represent that they are admitted to practice in that place. So again, they shouldn't be telling people that they can handle cases for the public or for people in that jurisdiction if they're not admitted to practice in that place. If a lawyer does any of these two things, he or she will be considered to be practicing law without a license, and obviously that is grounds for discipline. The next part of this rule discusses that there are 4 instances in which a lawyer can practice law in a place in which they are not licensed, but only on a temporary basis. So here the rule says a lawyer admitted in another United States jurisdiction and who is not disbarred and who is not suspended from practice in any jurisdiction may provide legal services on a temporary basis in 4 scenarios. The first scenario here is if it has some sort of reasonable relation to the lawyer's practice. The rule specifically states that if a lawyer's services are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice, then temporary practice would be permitted. So to give you an example of this, let's say that the officers of a multinational corporation are surveying potential business sites, and they seek the services of their lawyer who is not licensed to practice in that jurisdiction in which they are surveying. These relative merits of each of the sites. Under these facts, the officer's lawyer here can help in assessing the merits of each of these places, despite the fact that he or she is not licensed to practice in that jurisdiction. But again, it could only be on a temporary basis. The next exception to when a lawyer can practice in a place in which they are not licensed temporarily is if they associate with a lawyer who is admitted to practice in that jurisdiction and who's actively participating in the matter. The third exception, they say, is if a lawyer is allowed to practice temporarily, so they can participate in some sort of mediation, arbitration, or other alternative dispute resolution proceeding in this or another jurisdiction if those services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which they are admitted to practice law. And then finally, the fourth exception in which a lawyer can practice law in a place in which they're not licensed is if they seek special permission from the judge. This is what we call pro hac vice. So this would be the scenario where, maybe a lawyer wants to take on a case in a place in which they're not licensed. They would file a motion, and in that motion basically outline for the judge all of those things that are hoping to accomplish and handle in that place, and then the judge can take it from there and decide if the lawyer can move forward with that representation or not. The next part of this rule, we're still not done, discusses the exceptions. Basically, when a lawyer can hold an office in a place in which they are not licensed to practice and not get in trouble for doing so. The rule states that a lawyer in good standing who's admitted in a different state or foreign jurisdiction may have an office or other systematic and continuous presence in a jurisdiction if, one, they're employed by only one client. So, for example, let's say they're in-house counsel for a client. They're some sort of corporate lawyer. Or if they're a government lawyer working for some sort of office or agency. But it's important to note that under this rule, if the lawyer wants to litigate, then he or she must seek special permission by the judge to be able to do that. And then the second part of the rule says that if a lawyer is permitted by state or federal law, then they can practice law in a place on a regular basis, though they are not licensed there. So, for example, if you are licensed to practice law in New York, but you want to practice immigration law in California, you can do that since immigration is federal law and only requires that you're licensed in one jurisdiction. Shifting gears just a little bit, but the next rule from this subsection that I would like to cover is all about fees, specifically fee divisions with non-lawyers. This is a rule we get a lot of questions about. So the rule says a lawyer or a law firm shall not share legal fees with a non-lawyer, except in the following circumstances. The first set of circumstances is an agreement by a lawyer with the lawyer's firm, their partner, or their associate, and they can provide for the payment of money after the lawyer's death to the lawyer's estate or to specified persons. So again, this would be the lawyer or the law firm sharing fees with a non-lawyer if they're giving it to the lawyer's estate or the lawyer's family, but they can do this under this exception. The second exception to when they can share fees with a non-lawyer is when a lawyer who purchases the practice of a deceased, a disabled, or a disappeared lawyer is allowed to pay the agreed-upon purchase price to a non-lawyer. That is permissible. The third exception discusses that lawyers or law firms are allowed to include non-lawyer employees in compensation or retirement packages and plans, even though that plan is based either in whole or in part on some sort of profit-sharing agreement. Again, I think this exception recognizes that law firms oftentimes employ people who are not lawyers, and of course those people need to get paid. This exception allows for that. The next exception says a lawyer or a law firm may give out bonuses to non-lawyer employees that are based in whole or in part on how much money, including legal fees, overall firm has made over a period of time. Again, I just kind of think of this like the previous exception. It makes sense that if the law firm wants to set up some sort of bonus system for its employees, it can do so even though that employee is maybe a non-lawyer. And then the final exception is that a lawyer may share court-awarded legal fees with nonprofits that employed them, retained them, or recommended their employment in the matter. So if a lawyer was retained because the nonprofit recommended them and they say win that case in money, they can turn around and share those winnings with the nonprofit permissibly. And then the next and final rule that I want to cover from this subsection is all about the sale of a law practice. So here the rule says a lawyer or a law firm may sell or may purchase a law practice or the area of a law practice, including its goodwill, if all of the following conditions are satisfied. So what I'm going to do is just take up each requirement in turn. So the first requirement is that the seller has to cease to engage in the private practice of law or in that area of practice that has been sold in the geographical place in which the practice has been conducted. So a few different things could be happening here with this requirement. This is saying that if you're selling your whole law practice, and let's say you're a general practitioner, you have to stop practicing law in that geographical place. Another thing that this portion of the rule is saying, let's say you have a general practice firm, and let's say your probate practice is getting very large and you're looking to sell it, and you sell that probate practice to another lawyer or law firm. This rule is saying that you can no longer practice probate law in that geographical place. So again, you just have to read your fact pattern carefully here. There are kind of some exceptions to that requirement because that's obviously very broad and quite strict. One of the exceptions states that returning to private practice as a result of unanticipated changes in circumstances would not necessarily result in a violation of this rule. So, for instance, a lawyer who has sold the practice to accept an appointment to judicial office does not violate this requirement if the lawyer later resumes private practice upon being defeated in judicial election. Another exception is that this will not prohibit employment as a lawyer on the staff of some sort of public agency or legal services entity that provides legal services to the poor or as in-house counsel to a business. So if you sell your law practice, you can stay working in that general geographic vicinity if you are now working for some sort of legal services organization or if you've transitioned in-house and only working for one client or one corporate client. So that's the first requirement, to be able to ethically sell your law practice. The second requirement is that the entire practice or the entire area of a practice is sold to one or more lawyers or law firms. What this basically means is that if you're going to sell your whole practice, the whole practice gets sold to the purchaser. The purchaser cannot pick and choose what they want to buy based on how much money that practice will make them. The third requirement is that the seller has to give written notice to each of their clients, and this written notice must basically include information regarding the proposed sale, the client's right to retain other counsel and to come get possession of their file, and it must include the fact that the client's consent to the transfer of their file will be presumed if they do not take action or do not object in some other fashion within 90 days of receipt of this notice. So that's very important. Basically what this is saying is obviously your clients need notice that this is happening, but they need to be given all of the relevant information. They have to be told that they can obtain a different lawyer if they want, but if they do nothing at all, we just presume that's because they're consenting. And then the final requirement as to the sale of a law practice is that the fees charged to existing clients shall not be increased by reason of the sale. So what this really means is that if you have entered into fee agreements with clients and whoever is purchasing your practice is taking over those files, they have to abide by those fee agreements. They can't just start charging those clients more money. However, the person that bought your practice can start charging new people more money because there's not an existing fee agreement between them. So that's where we're going to stop for this first subsection, and then we'll pick up with the next subsection of the rules next.